Hi, hello, welcome to Immigration Show on every Wednesday on Telugu NRI Radio with Lucas Garritson. So today is a very good news. Who are seeking for green card? Department State is releases June. June visa bulletin is a wonderful day. The EB2 and EB3 is a more very fast. It means EB2 is more almost 4 months. EB3 moves on 9 months. So it's a very good news. As for this June visa bulletin, everyone little bit worry and want to get more information. What needs to be done next couple of months, and recently last October, a lot of people is downgraded EB2 from EB3. They do have a lot of questions and confusions. Today, we will clarify those questions and we will ask the right direction and the suggestions. And if we need to take any precautions, we can get from Lucas. So, well, I just invite Lucas. Hello, Lucas. How are you?
Doing well, Venkat. How are you? It's great news. Great to be back this week.
Yeah, it's great news.
So, as everyone's probably reviewed by now, we've already seen the visa bulletin for July 2021. We saw a tremendous movement, just like Venkat and I, discussed last week. And, pretty much have been predicting, this past few months. We still continue to see, exceptional movement, especially EB2 category. Where we were this time last year was, I think, May 2009, and now we're obviously going all the way to November of 11. So, it's great news. I've had a lot of clients who've, already been receiving notices that maybe, the medicals are due, so they can go ahead and continue processing. There's still also some good news that maybe the interview requirement might be waived. I'm still waiting to hear back from some other people about what they've experienced. So, it's very good news.
Yeah. So, look, we can divide the questions, and first we go for the last October 2020 adjustment of status. The most of the green card holders are downgraded to EB2 to EB3. So let understand. We know that EB2 is filing date went to 2011 May. So after 2011 May till December 2014, the most of the EB2 category is downgraded to EB3. So now, what is your suggestion and precautions? So EB3 is moving very fast. Even so, we were expected only it moved to the 5 months in the EB3 category, but surprisingly it moved to the 4 months ahead. So we do have the next 3 months of July, August, and September visa bulletins. Maybe we can expect each month is minimum 4 months or 5 months. Maybe we can calculate it. Maybe it will end up December 2022 or maybe first quarter of 2013 might be in EB3 categories. So these categories of EB2 downgrade to EB3, can you suggest to go ahead and start the premium process?
Yeah.
Or what is the consequences if we apply the premium process? And you can share your thoughts.
Yeah, that's a good point, Venkat. And I do want to share this with our listeners. There's been a lot of discussion, what's going to happen as far as like have a placeholder, have I-140 file that's pending. What should we do to move forward? My dates have now they will be current with the final action date. So here's what I would recommend. And I spoke to multiple people today about the same subject. I would go ahead, if it looks like your date is going to become current in the downgrade category from EB2 to EB3, go ahead and file premium processing. That way, once I-140 is approved, you're pretty much locked in. That the final action date's current. They're going to start working on your adjustment status application. Again, you'd probably want to discuss with your employer or their attorney to make sure that everything's going to be covered. It is a case-by-case basis. You want to make sure that if there's RFE or anything else that you can address that. So yeah, definitely. This is kind of a good notification. It gives us a couple of weeks. Hopefully, some of these cases can go ahead and be approved within the 2-week time frame, which would get us to the finish line right at the first week of June.
Okay. So the same question we already discussed about this medical documentation. So. Mm-hmm. Even we discussed about the interim file application. So what is still we touch about this medical documentation. What do you think? Do we need to submit the documentation or just wait until get back from USCIS?
I would wait and get the notice back because the documentation is only going to be valid for 60 days unless you turn it into USCIS. And still with any interim filing, you're not 100% certain that it's going to make it to your file within the time, required. So when the officer is actually working on the case and you get that letter for the local field office to kind of finalize this or, whoever might be working on it, it goes right to the officer who's working on it. It's usually you can make the appointment within a day or two. Go get the medicals completed, and then just mail them in. And the day or two delay it might take to go see the doctor and do all this stuff is it won't impact your case much at all.
Okay. So anyway, we know that it means now EB3 is more to the 9 months, July and August. Maybe if you take the 4 months, another 12 months. So nowadays, November 2011, the 12 months is almost January 2013. Let's say, can we take a proactive to take a medical documents, be ready to send out, or just? The
medical documents are only valid for 60 days after you see the doctor. So if you submit them to USCIS, they're valid for 2 years. Okay. But if you go to the doctor and you don't submit them and they're sitting on your desk, they're only good for 60 days. So you have to, make sure you keep that in mind because it is somewhat expensive to have these medicals done, especially if you're filing with your family. There's $300 times 3 or 4 people. It can get expensive quickly. And if you don't use it, it's not beneficial to you. It's just more or less a waste of money, in my opinion. But, I would go ahead. Wait until you get notification, then handle everything accordingly. And you have to remember, there's been historic movement on this visa bulletin this past year, but there's also been historic filing. And whenever you have to think about all the hundreds of thousands of applications that are being filed and being processed. So there is the sense that if you try and do too much, or you try and file or downgrade, upgrade, or do all this other things, you might actually cause more delay than help your case. So the best advice I have is just patience is key. Let it run its course. And, at the way things are moving, it's not like the dates are going to retrogress to the point where you're not going to be able to have your case adjudicated. So wait for the notice, get the medicals done at that time, and then send them in, and everything should still be processed accordingly.
Okay. You talk about the retrogression. Here I need to discuss a very, maybe the sense is not a sensitive, but we know the Department of Status and analyze the numbers priority date and release the months for the final action date. But still no one understand what is the mathematical underlying the Department of Status. Lucas, October 2020, most of the EB2 category downgraded to EB3. So everyone is expecting EB2 will move far than EB3, right? But it reverse way, the EB3 is moving rapidly. It means 9 months and next couple of months, it will go, maybe I'm expecting next 12 months or something, but I'm not sure. So in this case, so what is the possibility to retrograde in EB3 category? It means when we can get clear idea, so that based on that, everyone will react and the proact to the situation.
So what I would recommend is plan for that to not happen for the next few months, especially all the way up into October. I would, if they were to retrogress, I mean, we're talking about people who have a priority date getting into, 16, maybe 17. That would be where I would worry at this moment, especially going into this next fiscal year. We don't really foresee that happening. There's an allocation of the 16.5% for each category. And so if you can imagine, it's just a large group that's going through. There's been a large influx of visas, and both dates will move somewhat rapidly. And obviously, they'll know by a number who's filed, who has not filed, or taken advantage of that. So especially once GCs are issued, the dates will still move somewhat quickly, because you're, clarifying if someone had two hats or two places in line. One, you can only wear one of the hats, so to speak, because there's only one visa that will be issued. Then that other holding place that was in like an EB2 category, it's going to go away, and it'll be obviously reallocated for the next person in line with the next available priority date.
Okay. Yeah, you explained that reallocated. When USCIS will reallocate those numbers, the ones issue the GC to corresponding I-140, or
once everything's approved, they'll know, like, okay, so Venkat has you have one A number, you have two I-140s, or you have two hats in the ring, so to speak, or whatever it might be. Once you get the GC and the process finishes, they're going to know that this A number, or whatever, whoever it is going to, any other application associated with it or petition associated with it is going to be non-essential or not needed anymore.
Yeah. So because it means most of the people are analyzing this, the EB2, EB3 downgrade categories, and everyone know the after 2012 and 2013, EB3 have the less filing in EB3 category. Most of the filings in EB2. So that's why I think we expected, because of this, it moved to the 9 months, because there is no numbers in between 9 months or 10 months or the 1 year. So as of October 2020, downgrade I-140 still is pending. The once it approved the I-140s, downgraded I-140s, do you think the date will retrograde back?
I don't see that happening anytime soon. I mean, let's say we're planning this time, this October, and let's say we have someone at EB2, but the EB3 filing date goes up to 2017. And I'm just guessing a number there. Let's say January 2017. Well, I mean, that's something we would discuss then, because there's no really practical expectation at that point in time that the final action date for EB3 would probably ever get to that date before EB2. And it certainly wouldn't, unless this pandemic continues on the way it's been, I don't foresee it, going in a way in the sense that the dates would not retrogress. Now, you and I have been talking about something else for a long time, since our show started, about comprehensive immigration reform. There's still two bills that are parked in the Senate. These are the two bills I believe that are going to have the hardest time going through, but also it's the most pressing, as far as comprehensive immigration reform goes, for a lot of advocates and other people who are here in America who need help. So as soon as we get finality on these two, whether or not they're approved or not, or there's changes made, soon to follow is going to be a bill addressing the high skilled workers, the visa backlog, things like this. And I think even if we see issues with the dates this year, I think it's within reason that by this time next year we could see the backlog being addressed in a completely different manner, where the country cap limit is maybe taken away, or more visas are allocated to get away get away from this whole backlog situation. So there's still a lot, on the table, so to speak. But in the meantime, this is great news, to kind of, clear up this backlog to try and move forward. And this reallocation of visas is really a, tremendous help. And, it's something we haven't seen in quite a while.
Yes, true. Yeah. So, Lucas, here I would like to discuss the GC numbers. We know that the 2021, the numbers almost 230 or 260 numbers. Let's say by October, end of the September, end of the fiscal year, let's say USCIS issued only the 200,000 green card numbers. Whatever the leftovers will fill over to the next year bucket?
Well, so typically the way it works is Congress is the body that has the authorization to issue these visas, okay? So every year that's going through, this is pretty much statutorily set up to where this many visas are going to be issued. It's going to be broken down into these categories, so on and so forth. So once Congress allocates those visas, it's really kind of an idea, if you're thinking about it, if you're making a comparison to anything, it's, something's, if you're working on a budget, let's say you've been budgeted a certain amount of money, but the budget is, you're going to have a budget surplus. Maybe on the project you're working on, you're more efficient than what you thought. Well, you don't want to give back money at the company you're working on if you're working on a project, if you have a surplus. So usually, someone within the company will reallocate or find other uses for that money so that you just don't lose the accessibility for that. So it's the same thing with the visas. We don't want to ever just return the visas back unused. We want to, Congress authorizes, it's pretty much like printing money. Here's this. We can't, the president himself can't just print more money. The USCIS can't print more money or more visas. So we want to use what's been allocated. So, there's a very high probability that, again, all these visas will be reallocated, especially from the family-based perspective to employment-based.
Okay. So I think maybe as you discussed, the next couple of months, it will not be retrogression. We know that next year also it will adding the almost 140 plus the 130 additional is a total 260 or 270 numbers, GC numbers. So I think next year also will move forward. I don't think it retrograde the EB3 category. I think so. Just is this right, or what is your idea?
I think that's pretty much in line with what I'm thinking. But on top of that, I think we're going to see some sort of action from Congress, from the president signing it into law, that's going to help eradicate this backlog. So in the future, we get back to what we would think is normal operating procedures, where if you're here on H-1B visa, that it's not a life sentence before you can get GC, that, you have to wait all these years for something to come through. I mean, I speak to people all day long, every day, and high skilled workers are specialized in technology. Most of my clients are on the cutting edge of developing new software technologies, using new tools, such as Amazon Web Services or Python, or all these new, languages and environments that are out there. And if someone's on the cutting edge of that, we want them to have an entrepreneurial spirit where they can apply their skills to benefit not just themselves but our country. That would help increase and improve our economy, and that's the main goal. And I think once that's communicated effectively to Congress, I think we can get everything back to normal, where someone can come on H-1B, realistically expect to only stay in that status for maybe 6 years, and then progress into GC and eventually citizenship.
Okay. So, Lucas, we need to. I have a question about the premium processes. Did you apply any premium process recently? Do you see any RFEs? If yes, what kind of RFEs are USCIS is giving?
So we have applied premium, but unfortunately, I have not received any RFEs yet. So I can't give any input on that. I hope, knock on wood, I hope we don't receive any RFEs. We just keep getting approvals. But at this point in time, I haven't received any. So I don't know what the trend might be.
Okay. So what is the fee for premium process? 2,500 or?
It's $2,500. So last year it increased, from $1,440 to $2,500.
Is there any chance to go back to 1445 or 1250?
Well, I wish, because the whole purpose of increasing from the 1440 to the 2500 was that the Trump administration said there was a huge budget shortfall, and USCIS doesn't receive any funding from the government, so everything that the funding they receive to operate is derived from fees. So they received permission from Congress to up the price, which they did, to the maximum limit. Hopefully, I think this is one of the issues that are being reviewed still by the new administration to see if that requirement is still needed to maintain the agency operating in the black. But we'll have to wait and see how that goes.
Okay. Yeah. Thank you, Lucas. We have a couple of calls and conference. We can go for the Srinivas. Boloju Srinivas. Do you have any questions? You can go for it.
Hey, Srinivas.
Are you mute? Or so I think yes. Yes, please. Hello. Yeah, I think the network issues. So maybe we can.
I have applied my this thing in April 2020. That is the priority date. It's very late. So, what is the waiting time? Can I expect? Is it like 10 years or?
Well, Srinivas, that's a good question. I hope we don't have you waiting that long. Like what Venkat and I have been discussing, I think, we have both the short-term and long-term hopes. Short-term hope being this current backlog for people that have already been waiting 10 plus years will continue to progress and help clear up the backlog. Long-term solution, I hope Congress does something to address this backlog where, you won't be having to plan around the future, how long it's going to take for you to get GC. Hopefully we can have something where you can, have some sort of expectation to have GC in hand within a reasonable period of time, whether it be a couple of years or 5 years or something like this. At the moment, the way things were progressing prior to this last year, one could expect 50 to 60 years processing time, and that's just unconscionable. That's and I really believe something's going to be fixed, but how soon we don't know. That hopefully, if things keep progressing this way, it might be maybe 4 or 5 more years before everything's back to normal, so to speak, where you could get your GC.
Yeah, thank you. Thank you.
Yeah, I have my kid. Like 13 years. That H4 aging factor. He will turn 21 in like 7-8 years. I don't know whether this will come before that or.
So your GC probably will not come before that, but as part of this new bill that was proposed, I think if you want to go back and listen to it, I think Venkat and I discussed it maybe 2-3 months ago. there's an age out provision in this proposed bill. Now, the legislation hasn't made it to the House yet or the Senate. So, whenever that does, we do want all of our listeners or anyone who, that you know of, that might be in that situation like you, Srinivas, we want to reach out to all the representatives, the congressmen, senators in your district, and we want them to know that, look, here's my situation. I'm here. I'm a high-skilled worker. I'm H-1B holder, visa holder. I pay taxes, et cetera, et cetera. My son is this age or my daughter is this age, and they're going to age out, and I'm going to be here in the legal permanent resident status, and they're going to be left out, and we want to stay together as a family. So I think that's a very real chance of passing here within the next few months. But as we get more information, as more things happen, obviously we'll convey that information to everyone that's listening. And we do want to try and take action ourselves. We have the power to call, communicate, write emails to our leaders. And, our voices are important. Whether or not you're a citizen, it doesn't matter. You're still living here paying taxes. So, that's a good question. And that's something that hopefully we can get resolved where we protect all the kids from aging out.
Yep. Thank you, Srinivas. Thank you.
Thank you.
Yeah, we can go for next call is last 4 digits 8028. You can go for it. The phone number last 4 digit 8028. Okay. So yeah, we can see later. Lucas, we have a.
I'm sorry. I was on mute. Hi, Lucas.
Okay.
Hi,
Yeah.
Hi,
Your
Lucas.
name and
so I have a question.
Your name, please.
I'm Kiran Kumar. My wife is on H4 visa. So, what is the scenario if you would like to transfer H4 to the F1? Because she hasn't pending visa status. Like recently, I have transferred my employer, and my H1B got approved, and but my wife's status was still in pending. She was on I-539 pending status, and I would like to know if she wants to transfer to F1 again. So, what is the scenario? Are we need to transfer right now, or I would like to know the scenario.
So, while your wife is in the process of changing her status, while that I-539 is pending, you are, she's still maintaining her status, even though you don't have an approval. Now, I've been able to do this in the past, and other attorneys. Sometimes the DSO will tell you have to wait for the approval notice before you can file. That's technically not true. As long as you reactivate the CVIS or get a new CVIS, she should be able to transfer or change her status back to F1. And she should be able to continue going to school if she's enrolled at the moment while that process is pending. But what you would want to do is reference the receipt and, you apply to change back, because traveling outside the states right now to get stamped and come back in is really not an option with the current pandemic and everything else going on.
Sure.
Okay. I think Lucas.
So what users these? Yeah.
What I would suggest is speak to the DSO, depending on, each school has their own policies about what they will accept. Go ahead and reactivate the CVIS and have that conversation with the DSO, whether or not she's going back to the same school or enrolling in a different, university. And then once you get that process started, just say, she's maintaining her status here. She has a pending application to change her status. And if you need help, an attorney can help you with that, or the DSO should be able to help you with that as well.
I spoke to the DSO, but the DSO, they couldn't able to help me enough changing the status right now. But she can enroll as a student, but my question is, when should we supposed to change the status? Like, am I supposed to wait until her visa gets approved, and then I'm supposed to change to F1, or is that okay if I'm gonna change my status? I mean,
so
go for a new petition then.
So Srinivas, that's a good point.
Kiran.
It's a good question. I'm sorry, Kiran. Kiran, that's a good point. What I would recommend is if this was a normal time, you know, the fastest, easiest way to do this would have been to just travel, get stamped, come back in at F1 status. But since that's really not an option at the moment, there's really nothing that would hurt for her to stay in the pending H4 change of status, unless you're worried that you might end up losing your H1 visa or your job, or you're not able to maintain your status. And if that's the case, because her H4 is going to be tied to your H1, so that might cause an issue. But in the long term, if everything's fine, as of right now with the pandemic and everything the way it is, I would just wait. If the DSO is wanting you to take that action, by all means, just it doesn't hurt to be in H4 and attend university.
Yeah, you're right. You're absolutely right. But yeah, the only concern is like, if we, she can enroll as on H4 visa too. But yeah, so what you suggest is like we need to wait until the status need to be approved and then go for the F1, right? That's what my understanding, right?
You don't need to. I've done this before. We've done the change of status on receipt. That's possible. But if, obviously the DSO has a little bit to say with, how to proceed with the case. In the past, I guess the best course of action would be just to travel, because as soon as you leave the United States and you have a pending change of status or an extension of status for like a I-539 for H4 or F1 or not, L2 or something like this, the application will be deemed denied because it's been abandoned. And then, because as soon as you leave the United States, you're not changing status anymore or extending your status in that sense. Mm-hmm. And you would just go and either get stamped or re-enter with a fresh I-94. So in this case, since you can't travel, I think patience is going to be key.
Okay. So what is the normal average waiting time for a pending visa for I-510, and like what is the normal pending time?
Well, there's no normal. As we all know, we've discussed on the show, there's been extreme delays. But I think the average processing time now is anywhere between 6 and 9 months. I've seen some getting close to 1 year. It just depends on the service center and when the application was filed, to be honest with you.
Okay.
Okay,
thank you so much, Lucas.
Thank you.
Mm-hmm.
Thank you. Call. Yeah, I have the call, and last 4 is at 7875. You can go for it.
Hey, hi. Good evening, Tommy. This is Nandan. I might be sounding like a weird question, not a novice question. Actually, my case is filed in EB1, and my 140 priority date is April 2019, and my 485, 765, 131, all are being filed in October 2020. Mm-hmm. So wondering, do we have a separate quota for the EB1 category, and how does 140 date and 485 date come in the picture? What do they have to do?
So basically right now your dates are current, and you said your I-140 was already approved, correct?
Yes, it is approved and with a priority date of April 2019.
So your petition's being worked on right now. Obviously there's a lot of evidentiary scrutiny that's already been done, and your I-140 has been approved. So at the adjustment of status stage, you just have to. It depends on which service center has the case. I've seen anywhere from a year and a half to 2 years sometimes on some of these cases. And then, of course, you have to also remember, any other outside requirements. But have you already received the GCEAD and advanced parole?
Not yet. Still waiting for that. I've completed my biometrics on March 6th, and it's been like 70 days now, waiting for my EAD yet.
So, sometimes I've even heard of, I've seen it a few times myself, where you'll get EAD within a short period of time of getting GC because of these delays. But what we can do is you can look at the processing times on the USCIS website. We can, but depending on what service center it is and everything else, we can determine what the normal processing time is. If it's outside of those processing times, you have a few options there, whether or not you could file a mandamus action to, through the district court to speed up to have a decision made. You could also write to your congressmen and senators, asking for help with your case to see what the delay is. Sometimes USCIS will tell you, they're doing background checks or administrative background checks or something like this into your record. And so dependent, there's a lot of different reasons why it could be delayed like this, but you do have certain recourse to prevent this from, dragging on for years. So I would just recommend the first step is always the best step. Write a letter or an email, work with your local congressman or senator. And obviously if you're EB1 like yourself, that they should be more than happy to work with you and help hopefully find resolution to your situation.
Okay. Yeah, thank you. That helps. But I think so another basic question which I was asking is, do we have separate quotas for the EB1 category on the visa?
It's not so much quotas as it is an allocation. So you have different allocations of visas to be issued. So your visa, there's sufficient numbers right now for the EB1 category. At times, and I don't know which EB1 category you're in, if you're EB1 A, B, or C.
I think it is C. I don't know, but it's international manager category.
So you're executive or manager?
Yes, I am.
So EB1C. So what they've been looking at and some of the flavors of what's come through is, and I don't want you to answer this, obviously, I'm just giving you an example. We don't need to share any personal information about your case, but let's say, you've worked with a company, and this is really a common way of things, how they're working. You have maybe a cousin or a brother who has company, and you're working together maybe as a family. And let's say that your I-140 is approved and you're here on L1A, and now you're applying for adjustment of status. Well, maybe there's a little look into the background to see if there's a certain family relationship. Maybe there's a look into your background to make sure and verify the companies and things like this. So even though it's not an official adjudication, because that was done at the I-140 level, I have seen it where there has been delays in adjudicating a case because they want to do these quote unquote background checks or whatever. And you do have recourse if this drags on too long. Like I said, number one, contact your representatives. Say, my case has been pending for X months or X years. Can you help see where the status of my case is? That's number one. Number two, you also have recourse if it's beyond a certain period of time. You can work with an attorney and file a lawsuit with the United States District Court that's pretty much, you're asking a judge to say, USCIS, you're not processing the case in a reasonable time. You need to make a decision on this case one way or the other within X number of days. Okay, that's what we call a mandamus action. And then number three, something you could do if you wanted to, you could always just put a request in with the service center itself and just say, look, my case is outside normal processing times. Can you give me an update?
Okay.
Okay.
Thank you very much. In fact, I have probably picked up the last option. I did have a service request because my 131, the AP is out of the normal processing because my case was filed in October 2020, and now NBC is processing December 2020 cases, but I don't have an update yet.
So that's something to keep a look into, keep track of. What state are you in?
I am in Atlanta.
So if you're in Atlanta, that's probably a good place, to raise the request. Reach out to the two senators there, and then also your local representative if you're in Fulton County or wherever it is. Yeah, and I don't know I forgot the congressman that's there, but reach out to the congressman and their office, and you can go to their webpage on all three people, the two senators and the congressman. And you should be able to access the webpage and ask for help in regards to, they have offices or office members who help, be a liaison with your case to help figure out what's going on. How can we help you speed up the process with this agency, so on and so forth. Okay.
Yeah.
And that doesn't, you're most welcome. And don't worry about being worried about drawing attention to yourself. That won't, some people are shy or worried about if I bring this up or mention it to this person, maybe something bad will happen. Don't worry about that. That's what they're there for. They want to help you. Okay.
Yeah.
Yeah.
Thank you very much.
Thank you, Nandan.
Most welcome.
Thanks for calling. Yeah. Yeah. Lucas, we have questions on Facebook, YouTube. So one question from Naru is, I have EB2 Y140. Can I submit another I140 in EB3 category using same EB2 form? What are the consequences? I mean, any impact to the EB2 Y140?
So if you're completely submitting a completely separate case, it won't impact the other approved I-140 in the sense that would be. Now, that's a little different than downgrading, which is pretty much more of a safe bet moving forward. So just remember, one of the requirements whenever you're doing a porting is you're wanting to make sure that the duties and responsibilities and things like this match up within a certain amount. So it's a same or similar position. So that's something you'd want to talk with the attorney who's handling your case to make sure you meet those requirements before you do that. Okay.
Okay. Lucas, I have a question. You talk about the new petition and downgrade, right? The new petition, it means it should have both two I-140s for one petition.
Two I-140s for one petition.
But EB1, EB2, and EB3.
You mean for an application? So the adjustment status is going to be an application. It gets confusing. So I think you're referring. So what you would want to do is you'd want to file your adjustment status application, and we see this more common with family-based petitions. So family-based petition. Let's say I have a brother or sister who filed a case for me, and they're a U.S. citizen, and my priority date is X. Now, that usually is a waiting time of 15 to 20 to 30 years, depending on what country you're from. And then now let's say one of my parents becomes a citizen. Okay. So the priority date for that is much sooner than for brother or sister. That's the fourth preference category for family. So if you have something filed and then the final action date becomes current, we can supplement that with a supplemental I-130, much the same with the employment base. You can supplement the pending adjustment with an updated I-140. So that's what you would be referencing here. But again, what Venkat and I have talked about, for almost 1 year now, is everything you do has to have a purpose or strategy. So what is the purpose and strategy of this plan? if your priority date is 2012 January, I mean, maybe it's in your best interest just to hold tight, and if you're not sure what to do, and just to see what happens with the dates. And this is a very good question. I'm very glad that it was brought up. And last week, Venkat and I discussed maybe some other information that's out there from other law firms, soliciting people to go ahead and hurry up and refile I-140s because the priority dates are moving, and to be prepared and everything like this. And that's kind of a full-hearted way of moving forward and looking at things. What you want to do is examine real facts and see what happens. Today we saw the facts as they came out with the new visa bulletin for May. Now, if 1 month ago, if I'm on here telling you, hey, hire me to file your I-140, let's downgrade and do all this stuff, and we look at the visa bulletin today, and that was completely unnecessary. A, you wasted a lot of money, and B, how does that impact your case? Like, how would that affect what's already been there? I mean, what if we get denial? What if we get RFE? What if there's something else that comes about? So it's completely irresponsible, and that's why everything you do has to have purpose and a plan. We don't just file just because we think something might be. It's my job as an attorney to help get a plan together, and we follow the plan. And we don't want to cut corners, and we don't want to do something where you waste money. That's irresponsible. So there's a purpose of this platform, and what we do every week. We want to make sure everyone's well informed, and I'm available. Venkat's available also for further discussion to make sure that we are keeping the right path moving forward. And the best thing we can all do is progress forward as a group, making sure everyone is taken care of. And, I really feel, my belief is that the dates are moving so fast. If we start focusing on what ifs and I'm going to file this just to have 2 done here and there, what it's going to do, it could hurt your case, but it could also cause a delay in your case. And that's something we don't want.
Okay. Yeah. Thank you. Thanks, Lucas. So I have another question for Maher. Is question about the numbers, visa numbers. They're based on USCIS site and Q1 2021 I-485 new and pending obligation by April 23, 2021 statistical data. I think USCIS issued only the 87,000, maybe approximately 87,000 new application and employment based. The 485 and approximately 160,000 is pending.
Mm-hmm.
So I think question, I don't see anything for the question. Maybe his question is, will issue the all numbers or not? Maybe.
Well, I think that this is a good idea to think about this. That's a very good question. So as we had unprecedented movement this past year with the dates moving, we also had unprecedented filing, right? So if you can imagine, we all spoke about this, delayed in receipt notices, delayed in biometrics, maybe even some people like rejected packages after 3 months of mailing. It's still no EADs right now, no advanced parole right now. So you have to remember the USCIS is not hiring extra people. They're not staffing up to handle this influx. They have their own limitations with what they can process. So I think the math and the numbers you stated are correct in the sense that that's a reflection of the processing capabilities and the capacity they have to move these cases. Now, on the second part, I think a good clue you have to look at is if those dates were becoming, or the visas were becoming close to being maxed out, I don't think we would see the dates progressing the way they are. And so the good sign is pretty much saying, hey, the visas are still going to be moving and being allocated for GCs because there's a sufficient number. But it's just right now we're being held up. It's a bottleneck with there's only X number of officers that can really process the case. And I've actually seen from my side, most of the people who are really set up to actually get the GC here soon are all, people who filed Supplement J, they didn't downgrade. And that's because there's, a whole steps removed where there's no need to adjudicate the I-140.
Okay. So I have another question from Narendra. If my dates are current and my 485 application is pending more than 6 months, then if the dates retrograde to still get green card, or do I need to wait until my dates become current?
So very good question, and I'll give you an idea of this scenario. I think 2008 or 2007, there was something similar. Not that the visas were available, but the filing dates were allowed to become, current for a lot of people. So a lot of people, the final action dates weren't moving fast enough, and then obviously they started to have retrogression issues and things like this, and people pretty much stayed in a limbo, and that's something we don't want. So you filed, everything's pending, and now you're year after year after year, you're renewing your GC EAD and advanced parole, and you're waiting on the dates to become current. Hopefully we don't get into that cycle, because I'm hoping that the lesson was learned. What is this now? Like maybe 13 or 14 years ago, that's not the best way to help alleviate a backlog, because a lot of the rules that we have now under AC 21 are more recent, where it allows you to port your job after 6 months with a pending adjustment status application from one employer to another. This all did not exist until here recently. So if 8-9 years ago, if something like this happened, then you would kind of have to be locked in with that employer and hope that nothing happened to your job until your priority date was current and they were able to issue a green card.
Okay, thank you. So another question from Lakshmi. The 485 filled EB2 and EB3, and both are current and final action date. Will USCIS request to withdraw one of I-485 before adjudication as both same alien number?
That's possible, or one could be by default just necessarily denied or withdrawn at that point. So what you would want to do is you probably would have the option of which one you want to choose. Like if you had two different employers, you would probably have the option in it. This would take a example like an RFE would be issued where you would have the opportunity to address that.
Okay. And same question, another question from Lakshmi. Maybe Lakshmi 485 application is transfer NBC to Texas. Mm-hmm. Is this normal, or is any kind of...
Oh, it's normal, and that's very good news if it's transferred. So I think we explained this last week, and just kind of a recap, whenever you file your case, this is very archaic. We actually have to file forms. We have your photos with it. Everything's put into a file, and that's going to be like your A file, your alien file. And whenever your priority date becomes current, literally someone will take your A file. Everything's going to be made sure that it's in order. Everything's complete, things like this. And they're going to transfer your file like, on a truck. And it's just like the courier service or postal service, that things come and go all the time. And then your A file is going to make it to your local field office. Now, in a normal pandemic, pre-pandemic time, you would go in for an interview, family members would attend with you, things like this. And it's still the case. The regulations still cite that's required. But sometimes GCs are issued, reserving the interview for a future date. So, we're seeing sometimes that's being waived at the moment because of the pandemic. But that's the purpose of this. When you go to the interview itself, your file, your forms, everything will be present. You'll have the opportunity to bring your medical if you haven't done send it in already, and the officer will verify all the information with you, verify your name is spelled correctly, ask you the questions under oath, and have you sign the application there in the office if everything's true and correct. And then after that, the green card is either issued or not issued, which hopefully in this case is issued.
Okay. So another question from SJ, what is the order in which USCIS work on applications? It definitely does not look like first come, first service.
So your priority date has a lot to do with the order in which your case is being worked on. So if you have a priority date that's a month or two before me, but we both were able to file in the final action date, if the final action date becomes current for you and not for me, obviously they're going to work on your case, right?
Okay. So one question is about downgrade EB2 EB3. After downgrade, can I be both on EB2 and EB3 even if I leave my employer who filled my original EB2?
So, that's a good question. So if you downgrade, obviously then you can always upgrade. And I think, that's something that we discussed. So your labor that was originally filed is there to be able to support this. For you, obviously you're already in EB2 category. You downgrade to EB3. The only caveat with what you're telling me is if you leave the employer or you change employers, obviously you would need a new labor at that point in time, and you would have to port your date. So if you run across this scenario, maybe it's best if you get your I-140 approved, and if you downgrade it into EB3, go ahead and make sure you have that in your hand. So if something does happen and you have to change employers, within 6 months of your adjustment pending, you can just go and get a supplement J from your new employer, and then continue the processing of your case.
Okay. Lucas, next question. If I move to a different MSA location, either client change or self-move to other different location, do we need to fill the GC perm labor again?
So what you're referring to is if you're in H-1B status and you change your MSA from point A to point B. So when we file the labors, you or your employer, whenever it's filed, designates the work area. So the work area is going to be for the future employment of whenever you have GC in hand. So different companies have different policies on how this goes. If you're part of a consulting company, usually the practice is the employer's address is listed as the primary work location. And in the past, people have put unexpected or unanticipated work locations between then and now. So the idea is, obviously H-1B has its own regulations. You'd want to go ahead and make sure you file an amendment for your H-1B. But let's say your GC is not going to be issued for another 2 years or 3 years, whatever it might be. Well, there's no way of you knowing exactly. You might file 2 amendments in that period of time. We don't know. So the permanent address that was listed on your ETA is like if it was the petitioner's office address or something like this, that should be fine. There are some large companies that, are very keen on, you're working in Chicago, but now you're perm, you're going to be working in Seattle. They'll actually require the process to be reinitiated. So it has multiple factors involved. But if you're purely just asking me, if you're working for a consulting company under H-1B, you need to check with your employer or the attorney. And I'd say probably 9 times out of 10, you're probably okay with that. You wouldn't need to redo your labor.
Okay. The same kind of LC and amendment for, I think this is the H1 amendment LC approved for the new location. What means that means the current location petition automatically expire, or it valid until expiry date on previous approved petition?
So what you're asking is, I have H-1B right now for duration here in Dallas. I filed an amendment for H-1B in Houston, and the amendment's approved. Is my Dallas H-1B still valid? Is that what you're saying?
That's true, yes.
You should still be able to work under a previously approved primary petition, like if you're going back to the original client side or whatnot. Again, there's some other regulations and rules in play with this. You'd want to talk to your immigration attorney and employer about this, but if there's brief travel or temporary need, that's always permissible under H-1B guidelines.
Okay. So I have another question on the amendment and LCS. If I move to the same MSA location but different state, border cities, do we need to file H1 amendment or LCA again?
So the rule of thumb on something like this, let's say you're in the tri-state area, which I think is Pennsylvania, New Jersey, New York, right? And let's say you're in what's the name? North Jersey. I forgot the name of the city. Anyway, so now,
Philadelphia.
So let's say you're in Philly and you're going to work in Manhattan or New Jersey, whatever it is, and it's all the same MSA. So if you're in the same MSA, an amendment does not need to be filed with USCIS. However, you do need to file an LCA with Department of Labor and have that on hand. So let's say even if I'm working from one block away from where it's going to be, the best practice is always to have the LCA filed whenever there's a change in work location.
Okay. Yeah. Thank you, Naru, for your questions, and thank you very much. So, I'm seeing if any Facebook questions. I don't see any Facebook questions. These are the today questions and the scenarios. Which ones? Lucas, I want a couple of questions about are you publishing monthly newsletter? If I want to subscribe, where do I need to subscribe?
Oh, yes. Thanks for mentioning that, Venkat. So for this particular subject that we've been talking about for a while with the GC dates and everything, we're offering the ability for people to go ahead and register with this. We give updates, or if you have any questions, you can contact us directly through email or call us on the phone. And again, we're here as a support to the community. I think we can share the link for the form for just a sign up form. It's real basic and simple with your name and email and priority date and visa category. And if you need anything, that's what we're here for. And we appreciate everyone who's called into the show or sent messages, because it's a lot of great information, a lot of great input we have from the community. And just because someone might not be watching the live show doesn't mean someone has an issue in the future and they're able to reference this material for the assistance at that time. So we appreciate that. And if you want, I think Venkat has posted a link to the forms. It's real simple. If you need anything from us, like I said, it's no obligation. We're here to help. If you want a one-on-one consultation or answer any questions, we're here for free consultations, things like that, and to help the community.
Yeah, thank you. Thanks for the free consultation. Thank you very much for helping to community. So, the monthly newsletter and any updates subscription, we posted link in description. And if anyone want to the pre-register, or if you want to know more information about the upcoming visa bulletins and the JC trends, maybe if you want to pre-register, maybe the pre-register link also in description. Maybe go through this, up to you. There is no, yep. So, yep, that's it, Lucas. Is anything else apart from this you want to share today?
Nothing else. Just it's a great time. It's an exciting time, and we enjoy the work we do. But it's been rather hectic. We're in the middle of the cap, and we're focused on that, and then we get focused on the visa bulletin, and it's real exciting right now, and it's real positive times. So, hopefully things keep trending this way, and we're able to help see more of these cases approved.
Yeah, of the same, this excitement will continue to the next couple of months and next year also. So it's really good move on GC. So it's really great moment. Yeah, thank you very much, Lucas, today being with Telugu NRI Radio webinar. So we continue to the show every Wednesday on 6 p.m. Central Time. Until then, we see the next week. Until then, bye. See you. Can we take one question before closing, Lucas?
Sure.
I think one of the call added just now from Columbus, last 4 digits 4057. Yeah, if you have any questions, go for it.
Hello, Lucas.
Yes.
Can you able to hear me?
Yes, please. Your name?
This is Mihir, and I had a question regarding that statistical analysis data which USCIS has presented on April 23rd. Based on that file, it says like they have 87,000 new application and around 176,000 pending application as of in the first quarter of 2021, means like October 1st to December 31st. Should I assume that 87 new application includes all the downgrades and all those things, like it's all together is 87,000?
Yes. So that's a part of it with the downgrades and everything else is what was filed. So it's not necessarily that, that's completely new cases, obviously, because, like I said, there's a cross check that's going to be done. You can't get 2 GCs or 2 visas allocated. You can only get 1. So obviously a lot of people are going to have their hats both in EB2 and EB3. And this is something else we were talking about earlier, and I just want to, kind of reestablish the statement that there are maybe other people who give advice that we should go ahead and file I-140, downgrade, do this, and really all that's going to do is muddy the waters more and delay the process, I think, a lot for other people. And I think it's wise, and it's responsible, I think, to others. I think not just to yourself, but to others who are in this process with you. Let's all just be patient a little bit. There's no real need to file so much, because if in doing so, what that's going to do is cause a tremendous delay. It's going to cost a lot of money. If you want to, file as much as you want, most attorneys, I think, would be willing to take all the money you want to give them. But I think you have to be prudent and be wise about this to make sure that, A, is what I'm doing the best for me and my family right now, and B, is it something that's responsible as far as not just to me, but to other people in my community. And I think if what we're seeing with the dates moving so fast, I think until we see otherwise, I think we should all stand pat with the course we're on, and just make sure that my priority dates here, I think it's going to be current within the next month. Let's wait and see what happens. Whenever the new visa bulletin comes out, we're going to have a 6-week window to have everything ready to file, right? Today, if your priority date was current, we would have 2 weeks to have everything ready, and we could file the very first on June 1st. There's no benefit to you to try and guesstimate and then file something just to file. That to me it's just wasteful.
Sure. So I just have one follow-up question on that. So basically, by December 31st, like EB2 and EB3, like a filing action date was like around 2014 or maximum 2015, and for EB3 it was like January 2015, and EB2 it was like January 2000, around May 2011. So that data what they have published is first quarter of 2021, which is up to December 31st. So and we know that 120,000 visa, around 122,000 visa has been transferred from family to employment based. So if let's say if USCIS can able to adjudicate like 262,000 green cards. So should it safe to assume that like if every 122,000 extra green card has been adjudicated, then all people who file in quarter 1 2021 should get their green card?
There's a lot of factors involved. I would hope so, but again, there are certain circumstances to where, maybe especially EB3, if you're in 2013, maybe there's something where the date doesn't become current with the final action date. That's possible. But at the end of the day, like I was saying, I think most of these dates, especially EB2 and things like this, are going to become current in the sense that you would be able to go ahead and meet that final action date. Now, as you referenced the 85,000 other cases, I mean, that's a very good chance that, 99% of those are all downgrades, right? But USCIS is going to have data that we don't have, right? Any other attorney or any other person you hear speculating is speculating off of this data. We don't have the data that the service has. So the service is always going to be able to sort and check and verify that, okay, here's a number. I mean, what's to keep a person from having 5 or 6 I-140s? There's nothing. Let's say you have one employer who filed for you, and then you have another employer, that filed for you again, and you ported your date, and then because a lot of things happen over a period of 10 years, right? Well, you might have three I-140s in your name, but it's not going to reflect that. Your name's not going to be published. Your A number is not going to be published, right? But the service is going to know that. Sure. Does that make sense?
Yes. So but the inventory what they have published is 485 only. The applications are 485.
Correct. We have the 485, and then we can cross-reference historical filings for I-140s and kind of get a guesstimate of where we're at. You see what I'm saying? So that's what I think a lot of people do.
Yes, I got it.
So that's a good question. I think, I think anything in life is done, either optimistic or pessimistic. The whole process is something I think is, I haven't gone through it, but I think it's something valuable. And I think it's something that's, and why I chose this field is I enjoy talking to people and hearing their stories and things like this. And I think at the end of the day, you have to think of the big picture. You're going to be able to tell your kids, your grandkids one day, this is what happened, blah, blah, blah. I came here. Yeah, I mean, that's part of the American dream. And, we all get impatient. We all want things yesterday. But, keep that mindset that, this is a great process to go through. And, it's a story. So.
Absolutely. No, I completely agree with that, Lucas. Thanks for the information.
You're most welcome. Have a great day.
Yeah. Thanks, Call Meher. Yeah. Thanks very much for your
call. You. Thanks, Venkat. Thanks for
Thank you. Yeah. Thank you each and everyone who participated today, live show and questions. And we are requesting everyone to participate every Wednesday, 6 p.m. Central Time on the Facebook webinar. So Lucas said, and Lucas give the free consultation. Lucas, can you share what is the best reach out to you? Is a phone number or email?
Probably email. And if what we can do is do two things. If you can go ahead and register on the form, so I have a little bit of information with everything, and I can reference the email ID to who's calling. Or who's emailing me, that would be great. And then if you could send an email to the info@bgimm law.com, I can at least get back to you the same day to schedule, depending on how many people I'm talking to. There's a lot of students right now that I spend about 2 or 3 hours on the phone every day with, walking them through the CAP process. So I do first come, first serve. I'm open to, helping answer any questions anyone might have that wants to speak one-on-one. That's not a problem. That's what we're here for. And, I'll definitely reply back to you in the same day, but I don't know if I can schedule the time the same day.
Okay. Yeah. Thank you. So if anyone wants to look the consultation, just send first register your preliminary information and send an email to info@bgimlaw.com. Definitely Lucas will reply same day or will give the estimated time also. So yeah, thank you, Lucas. Thank you very much being with Telugu NRI Radio today. Yeah, we will meet next week. Until bye. See you.
Thank you. Bye.